I've had the privilege since I started JMB in 2018 to work with Klaas Junghans, and I've learned a lot from him, including on this topic that we're going to be discussing. But I felt the need that, in light of the discussion that we had at this lovely WhatsApp group that we have for bio patent attorneys in-house and in firms, that we can expand a little bit on this topic of European patents, the changes, and most importantly, what people are doing and practically, in light of the fact that this is actually moving forwards. There's been talk about it for many years, and it's actually moving forwards. So I'm going to pass over the baton to Klaas. Thank you, Klaas, for agreeing to have this little chat, and we're happy to hear from you.
Yeah, thank you very much. Yeah, my name is Klaas Junghans. I'm a chemist. With some friends, I run a firm in Berlin, Germany. We started in 2009, and I think for the first 2 years we didn't work internationally. We're mainly working with sort of homegrown clients. And once we started working internationally, we were in need of finding a US representation, and after a few ups and downs, we settled on Jeremy and his crew, Mike and Avram, and we've been working with them for, I think it is now 10 years, right? Doing almost exclusively all our US work through JMB, and we have quite a few correspondent firms in Israel. So Israel is our, I think, second largest non-German client of all our clients, and that's been a very entertaining and satisfying relationship. So thanks a lot for having us here. Yeah, as you know, we've been discussing the UPC for a decade now, and finally it looks like it's coming to fruition. So first of all, let me check. What is this about? Up in the upper left corner, you see the red countries. Those are the European Patent Convention countries. So when you designate an EP designation, that's what you get usually. Unless you opt out. The blue ones are countries that you can additionally designate, as you know. And those red countries are more than the European Union countries. So there's Norway, there's Switzerland, now there's regrettably the UK has left, Iceland has left, Turkey is not part of the EU. And so there's always this misunderstanding that the EP might be a European Union patent. It isn't. What you get when you are granted a European patent is a bundle of national patents. And so the inside of the EPC, the EU countries got together and decided that they wanted something unitary. In the end, Spain opted out. I think Croatia also opted out, but all the others agreed to have one common patent for the entire European Union. This is what you see in the upper right corner, the light blue countries. And as these things go, wait a minute, what happened here? As these things go, the decision-making process was kind of slow. And so in the spirit of the two-speed Europe, 25 of these 25 countries, a select few, decided to move on and start the European Unitary Patent Convention. And those are the dark blue countries. So it all hinges on one of the three large countries. Sorry, there's a problem here. Ratifying the treaty. This is Germany, which is always the last in all European Union legislation somehow, and they're expected to ratify the treaty in December, and somehow this is the chatter has grown so loud that we can believe that this is going to happen. So as of December, we're probably going to have these blue countries active and preparing to put the UPC in March. Why is this important? For those who are prosecuting, anything that is still in application will at some point have now the option to choose the unified patent as unitary patent as an alternative for national validation. And since the two countries, the two EU countries that are most often or almost invariably validated, which are France and Germany, they're both in the UP. Also Italy, which is also a fairly expensive country to validate in, the UP is a viable alternative to national validation for anyone. So anyone will have to think about this. Those who are close to allowance or even past allowance will have to make a decision very urgently about what to do. So this is for those, it's quite a pressing matter. And anyone who lives with granted European patents will have to make a decision about opting out, and I'll explain what that is in a second. Right. This is bad. Why is this? Sorry. Okay. So unitary patents relate to post-grant procedures. So anything that is pending now or is going to be filed or designated as a regional part of a PCT will have the option to become a unitary patent. Anything that is granted, any application that is already granted. The idea is that the prosecution, for some reason, I have computer. Do you hear me okay? Computer's wild.
We hear you fine.
Prosecution should not change at all prior to grant, and the UP can, but does not have to, replace validation in the participating states. So if you want to patent in Spain, which is not part of the UP, you will need to validate as before. Same for Norway, same for Iceland, same for Turkey. If you want a patent in Germany or France or Italy or any of the other states that participate, you have the choice. One really important difference is that, practical difference, is that the validation time to request a unitary patent is shorter, 2 months shorter than the usual validation time. So you really have to make up your minds before grant. So I would say at the time of replying to the allowance, the submission of grant fee and translations, you need to have cleared up if you're an attorney with your client. If you are an in-house representative, I guess it would be the time then to have decided with management or whoever is a stakeholder in this process to whether to apply for or to choose the UP way rather than the national validation way. And I'll come, and when we discuss the opting out, we can discuss whether that is advisable or not, or how people do it that we see. The idea for the unified patent, the unitary patent, is to have a cheaper process, no translations, and most important, to streamline national litigation. As you probably know, right now the litigation is for infringement and validity. Once the European patent is granted, is a national matter, and that's for many applicants a rather difficult process. The cost, the cost aspect, it is cheaper if you are bound to validate in most of the participating states, the unitary patent participating states. You will have a cheaper validation experience, and you will have cheaper annuity payments, but only then. And so what we see in almost all arts except for pharma is that clients, particularly foreign, sort of non-European clients, validate only in a handful of states. So usually it is Germany, France, the UK, sometimes Switzerland, sometimes Italy, sometimes then Spain, Denmark, Netherlands, Sweden. That's it. I haven't seen a non-European client do Turkey, for instance. Inside Europe, quite a lot of people choose Turkey. Quite a lot of people choose Poland. The Chinese are keen on Poland. The sort of the end of the Silk Road countries, but in general, the non-pharma clients choose 3, 4, 5 European countries, and that's it. For those, the UPC is not a great bargain. So what you could say probably is that if you are going to choose Netherlands, Denmark, Sweden, which entail relatively costly translation of claims, then the reduction in translation of claims will probably sort of weigh up the larger annuity cost for the next couple of years. So it's a bargain because you get a lot more countries. But generally, it's not. The cost is not going to drive the decision. And the only applicants that we see that usually validate across the board with every country, including all the small, San Marino and Malta and whatnot, are the pharma clients, and these anonymously seem to opt out. So I'll talk about this. For what they call a transitional period, which is probably going to be more than 6 years because there's an allowance of a little more than the initial 6 years of transitional period. There will be the requirement to file a translation along with the validation, and that needs to be filed the day that the request is filed. So again, it's this within the 1 month period. The thing is that unlike the validation translations, this is informational use only, and so our take is probably we're going to submit German machine translations. The translations from English to German are the patent translations from English to Germans are the texts that the DeepL and Google algorithms are trained on. And so unlike most other texts, these translations are amazingly accurate. We obviously do a lot of comparisons, and I'm always ghosted by how accurate they are, which is because they are trained on patent texts. And so I think this is going to be very, very reliable and probably extremely cheap. So the translations won't add a lot of cost. Ratification requirements. Again, I already said, assume that Germany will ratify in December. Assume that then the sunrise period will start January and in March, and from April 1st, we will have the UPC. And one other thing, it's whenever you enter a patent into the unitary framework, it will be valid as a unitary patent for the countries that are participating at the time of registration. So right now it'll be the blue ones in the lower, the dark blue ones in the lower left corner. And as more countries ratify, you can expect then that subsequent patents, but not that patent, will have larger coverage. Yeah. So in the sunrise period, and only in the sunrise period, not now, we are able to file an early request for unitary effect, which is sort of an entering into the system earlier than would usually be the case. And more importantly, we can request a stay of grant. So usually, once we filed the translations and paid the grant fee, the European Patent Office takes about 3 to 4 weeks to grant the patent, and then there's another week or two to publication. But it's a relatively quick process. If you reply to an allowance within the sunrise period, so after January 1st and before April 1st, you can request that the grant of the patent is halted until the UPC is in effect. That gives you more time to decide, to liaise with your client, to decide in-house what you're going to do, whether you want a UPC or not. So one of the practical questions is what happens if I am looking at an allowance or I'm expecting an allowance immediately. So there's two situations that you need to distinguish. One is you have received your allowance already. This is today, and the due date for filing the translations and the grant fee are due inside the sunrise period. So then the start of the sunrise period until the due date, that is a very, your time window is small or not, in which you can request stay of grant or early effect. I guess it'll be stay of grant because it gives you more time to decide. So keep in mind, any due date for responding to allowance 71.3 after January 1st, 2023 has a small time window to do these things, to give you more time. Of course, if you know what you're going to do, then you don't need it. The other more problematic situation is if your allowance has already issued quite a while ago, and the due date is sometimes in the next 2 months. Then you can expect that the European Patent Office will grant you the patent before the sunrise period. And the reason for that is that everyone expects that a lot of people will use this period. And so there's going to be some accumulation of grants after the sunrise period, which in the workflow of the European Patent Office is probably not going to look very nice, because then you have sort of a stacking up of oppositions. You have a stacking up of everything that is done in these departments. They're probably going to be on a big vacation in the first quarter of 2023. And this is something that they don't like. So they're probably going to create as much work for themselves ahead of the sunrise period. So if this is your situation and you want to evade it, you will have to file a response to the allowance which doesn't satisfy the grant criteria, so the filing of the claim translations and the grant fee, but ask for a small correction of the specification. our colleagues at JMB know this drill very well. Bella, hello. She doesn't need us to do any explanations. I've seen her doing the explaining to the clients herself. The idea is you always find something small that you can correct, and if it's only a comma or a spelling mistake, unfortunately, at least my own applications always have those. Or you can add, or more importantly, remove a few paragraphs. The European Patent Office understands this; they know this very well. And what this does is it moves. This is the old allowance and the old due date, and it triggers a new allowance. So this goes back to the examining division, but it's rubber stamped. I have not seen, in hundreds of these exercises, I have not seen one case where the allowance was revoked and a new communication, new office action was issued. It's just a rubber stamp procedure. And it pushes the next allowance probably ahead at least 4 months. So you're well inside the sunrise period with your next allowance, and probably even inside the UPC.
If I can interrupt you, sorry,
Yeah.
for a second. I see there's a question in the chat regarding how long the grant can be stayed for.
Until the end. So if you, thanks, Avram. If you use the form that the EPO supplied, the grant will be stayed until the UPC is in force. So count on a couple of weeks, or I mean, count on maximum a couple of weeks after the UPC is informed. But it will be stayed until the end of the sunrise period. So a maximum of 3 months, I would say.
Okay, thanks. So the reason why I'm so optimistic that this works is we do this actually a lot, and I wanted to share this because I find a shockingly large number of colleagues outside of Europe don't know this trick. So where this problem also arises, irrespective of the UPC, is when you're facing an allowance or a grant fee close to the annuity fee date. So if you have an allowance here and you have to file the translations, and you know that a couple of weeks later the annuities fees are due, then you have to make a decision: do I want to pay the annuity fees in Europe or in the validation states? If the application is still pending, then you pay the annuity fees to the EPO. Now, if you're planning to validate broadly, then the EPO annuity fees are cheaper than, let's say, 15 validation annuities. And in the case of across the board annuity, like, so the full 35 or whatever states that you can validate in need to be annuity fee paid, then this can amount to savings of 7, 8, 10,000 euro. So we've done this for a number of clients successfully. What we do is, again, we look at the due date, and then we submit a small correction to the specification, force another allowance, and then the annuity fee date moves into EPO pending territory, and we pay the smaller EPO annuity. So this is something we regularly do. We always advise our clients when there is a due date for responding to the allowance that this is an option, and we know it works, right? So the court. This is the more important part of this whole discussion, really. So the reason why people care about the UPC is
at least the ones that make use of their patents, is not so much savings or non-savings in the validation state. It is more the idea that with the unitary patent comes the patent court, which will allow to have one proceeding for invalidation and infringement at one court in the European Union to settle all questions. There's going to be instances, of course, as any proper legal system requires. So there's a lower court, an upper court, and the final instance in Luxembourg. It will rule on unitary patents and on the old school European patents. Legacy patents, let's call them, and it will its rulings will apply in all ratified member states. So if you're looking at litigation right now, there's a lot of forum shopping. You could theoretically, and few inexperienced people do this, file an infringement suit in my hometown, Berlin, which is not a great thing to do. Germany is a great place for litigation, but not any of the regional courts except for Mannheim, Düsseldorf, and Munich, which are enormously experienced, but this means that most of the other ones are not. All invalidation in proceedings go to Munich, and you know, if you're doing this, you settled the issue in Germany, but then you'll have to do the same in the Netherlands, the same in Denmark, the same in France, and so forth, with enormous expense. And so this is commercially a not very satisfying situation. So this is going to be taken care of by the new UPC, which and because this totally changes the legal framework for litigation, they created a system. So the old courts will persist in forever probably, because the future EP patents that are not treated as unitary patents will be litigated in national courts. There is an option to also opt out existing European patents from the system. Anything that is a unitary patent will be treated by the court system, by the new court system. So only the owners of legacy old European patents may opt out, and you can expect that they will be able to opt out at least for the next 7 years. I very strongly suspect that this will be possible for 14 years. There's an extension, and anyone who opted out has opted out forever. So anyway, if you have a patent that is going to run for another 15 years, and you opt out at the beginning of April, then this patent will be opted out unless you re-opted in for the duration of the patent lifetime. Your opting out is only possible until you've been sued or you've brought action yourself. So if you are the owner of a European patent and you forget to opt out, and someone challenges the validity of the EP patent in the UPC, in the new court, before you opted out, then it'll be litigated in the new court. Once you opted out and no litigation has been brought in national court, this is important, then you can opt back in. So it is possible for now to opt everything out, look at the system, and then go back in, unless you've been in court on the matter of that patent, either an infringement or validity in a national court. And then you can go back in if no litigation has been brought in national court, but then you can't go out again. So it's out, in, and that's it. Yeah, and so what's the discussion? I'm a chemist, so most of my immediate clients are pharma, or biopharma, or whatever in that space. The vibes that I got was everyone was talking about opting out, and the reason that people brought mostly were, you know where you are, basically. You know, that anyone who's an old hand in pharma litigation knows their attorneys, where to go, which courts to litigate in, under what circumstances, where the injunctions can be filed, and how the injunctions can be filed. And you know, it's just a routine. It's very expensive, but it's a routine. And for pharma, the very expensive doesn't seem to play such a big role. Cost of litigation is everything is known. Those people who discuss opting or staying in say, yeah, you know, it is rationally, it's the better system, the new one. The uncertainty of cross-national litigation is great, and the costs are just mind-blowing. And then one interesting aspect that I hear a lot is, you know, we'd like to somehow be in that new system and be able to shape it. And then for the pan-European enforcement, it does make sense. It will be a very powerful tool. If you win, the UPC is awesomely mighty. For the Germans, some aspect is that the UPC will then allow double patenting, so you can have a German patent and a European patent side by side again, and you can litigate one in the UPC and one in German courts. And so for those who are really keen on litigation, that's going to be another very powerful tool. I'm not so sure how that's going to shape up, and I'm not such a great fan of that idea, but let's see. So I called up a couple of friends in the business prior to this talk. The overriding scheme is that in many pharma businesses, people, the greater the organization, the more difficult it seems to be to come to a unified position here. But what is clear is that pharma opts out. We already received orders from some clients to opt everything out that there is. We heard that from one very large Swiss company, pharma company, that there is sort of a play in the different departments. So this is a company that has more than 100 attorneys in their department, and the IP department, that they're playing, that they're trying to make the people in the other department bring forward some of their patents to be left in the UPC system as bait. But apparently no one is really very happy to leave their own treasures to the mercy of the UPC. I've talked to people on the engineering side of our practice, and we called up the heads of departments at our clients. It looks like they want to stay in. So on the engineering side, there's probably a greater readiness to opt out only the weak IP. And the difference seems to be that in pharma, there can be $1 billion franchise can depend on relatively few rights. So you know, one big drug, the compound patent, and 1 or 2 use patents, formulation patents, can basically be the backbone of protection for a multi-billion-dollar revenue stream. Whereas in engineering, it's usually one product, 10 patents at least, and then there's a lot of different products in the market. And so the portfolios that these guys oversee are much, much larger, and the decision-making process is much more difficult. So I called up a friend at a very large, I think it's the largest German filer this morning, and asked how they were doing it, and he said that the individual patent attorneys had discretion over whether to opt out or not, and that only the key, the most important revenue wise, the most important patents were opted out, but people were quite willing to leave in. The costs for opting out or opting in are not clear. We've started looking at the process. It looks, so none of this is official yet. The website isn't up yet. There's a test website on. It's very easy to register. Anyone can register on there. In order to act before the UPC, you need to have a representation. So. But even that, to me at least, is not quite clear how it works. We have asked one of our colleagues to start looking at this process and set up a routine. My expectation is that we'll be able to register and opt out for, depending on what the deal with POAs is, probably at less than €200. And there's probably going to be a substantial discount for higher volumes with the same client. So that's more or less where we're looking at. I'd love to make it cheaper still. Not sure if that's going to happen. Yeah, and as a last, if anyone is interested, what do I think? I think it's a good thing. I'm an ardent pro-European. I don't like this whole national thing. And as we are now seeing in our existential conflict with Russia, we need to stand together. This is one of many small pieces of the mosaic that hopefully bring this about ever more. EPs, as you are probably more aware than we are too expensive to begin with. So anything that lowers the cost is a good thing. And the system will favor as you see, the larger one entity, the fewer, and the more value is concentrated on fewer patents, the more they're willing to opt out. So it seems like the system is favoring relatively small actors with strong patents, which is what we tend to represent, universities, startups. And so that gets me in favor of this system. Yeah, and then the sad thing is we don't really know very much about the cogs in the wheels. So if anyone is interested, Avram can discuss a follow-up in March when we will have all the websites up and running and all the routines, hopefully in March. So we can see how this works in practice.
Okay, Klaus, thank you very much for this informative presentation. I'm going to open up the floor for questions. If anyone has any questions, feel free to stick around for questions and ask. It seems to me that from what you're saying, the players here, are the more cost conscious you are, the more excited you are about this coming into effect, and the bigger patentee that you are, at least in the pharma field, it seems that you're not, you're not going to use this system. So I think the folks here, as far as I can tell, represent a diverse, number of types of clients. So I think everyone has to really determine what's best for their company's strategy.
Yeah, so we don't have large pharma clients except for one, which is sort of, it was swallowed by a startup was swallowed by a big one recently. But we listen to people in the large pharma community where we have contacts to. My advice to the startup clients will be to do what the big ones do, because that's ultimately going to be the driving decision. So anyone who's anywhere near closing a deal with anyone who is looking at allowance for a patent that protects an actual product under development, like a lead product, I would probably advise to go to file nationally. I would also advise to narrow the claims as much as possible onto the product, and then file a divisional. So this is something that we've done for a number of people very successfully. So you basically, you file you validate the first EP in 12 core countries, Germany, France, the UK, Switzerland, the Benelux, and the Scandinavian countries, Italy and Spain. And then you file a divisional, and you purposely narrow the claims of the first patent so that you can file a broader patent, which you are somehow optimistic about getting allowed, and which, due to this relationship narrow wide, doesn't run afoul of the double patenting provisions. And then you can easily delay the grant of the next patent until a pharma deal is done, and you don't have to pay for either the very broad validation of the decision about making the UP, because that's then done by the licensee. So that's the idea. I would not go for a unitary patent with a product centered European patent for a startup client who's looking at licensing in the next 2 years now. Although I like the UP, I think it's the better solution, and I'm fairly optimistic about it. But I think for positioning versus a due diligence or a licensing arrangement, I think the wiser decision right now, because in pharma, is to use the old route and make it cheap and file a divisional. It sort of pays for itself.
I have a question.
Yeah.
I work at the university tech transfer, and I'm thinking sometimes we have an exclusive license to only one licensee, and sometimes a non-exclusive. So it seems to me that if I have a non-exclusive license, I'd rather opt out, because I do not want a suit against one licensee to hurt the other one. But if I have an exclusive license, then based on what you said, I'd rather opt out, especially if I haven't licensed yet.
So and I'm not sure if you have an exclusive license, but you haven't licensed yet. I'm not sure what
No,
the
I have
situation
two.
is
There
there.
are two scenarios.
Yeah.
In case I haven't licensed yet, if I do not want to hurt the patent, then I'd rather opt out, because it seems it's similar to what you just recommended for startup companies, right? Not to hurt the
So
future
the,
options.
the first thing that I would suggest, this is my main client are TTOs, the Swiss TTOs. That's like 95% of my work, Swiss and German. The first thing I'd like to to touch upon is the litigation provisions in your licensing agreements. That's really important. So
Yeah.
if you are in any way responsible for costs for litigation, then you would definitely not want to opt out. This is something that, I mean, the litigation is going to be cheaper in the new system than in the old one. That's almost certain. So if you have a licensing agreement that forces you to participate in litigation in, let's say, the Netherlands, France, Italy, and Germany, that is just outrageously expensive. If someone drags you into conflict in all these jurisdictions, so you are much better positioned to stay opted in.
But we are hardly involved in litigation.
So even more important. So I mean that is even more that even speaks more to leaving it where it is. But so if you can only move out once, then back in once, and that's it. So I think your options are preserved. If the patent is not licensed and you don't have a licensee yet, then chances are that there isn't any litigation in the offing at all. And so I think you're still waiting for someone to take it. So then I think the better option is to stay in, because nothing really changes, and leave that decision to the licensee. If it's an application which is not licensed yet,
okay,
it's a problem. Where do you want to validate? I think you're going to get, depending on where, what the technology is, if you were always going to validate only in Germany and France, then you might as well do that. If you were going to validate Germany, France, Netherlands, and Italy, you'd probably be better off with the UPC, because at the same price, you take in Denmark, you take in Finland, you take in, Avram said I could expect mainly pharma people. So pharma is, those are the pharma countries. If you're talking about high tech, if you're talking about defense technology, you're going to see an enormous amount of business going to the east of the European Union. So Finland, the Baltic states, there's going to be, things will change in the next 5 years. I can tell you that.
So engineering, I'd rather opt
in. I would probably stay where you are with the existing patents and leave that decision to the licensee. For licensed patents, you're probably going to have to do what the licensee does or talk to the licensee. But I think also you're not favored by an opt-out unless there's a product. Unless you're in the position of big pharma, basically, you have you are on the strong side, and you don't care about litigation costs because you've excluded them, and you want your licensee to prevail, then opting out is a good thing. But at least in the license agreements that I know from our clients, this is always left to the licensee. So they're probably going to decide, and you're not going to be part of that. And for anything that comes anew, any patent that is granted in the next couple of years, you're broadening the license base by using the UPC. So you're getting more territory for less money. So I think it's a good thing.
Okay, so thanks for the answer to the questions and the presentation. I think if anyone has any further questions.